Good morning, everyone. Thank you for coming to listen to a bit about the Corporate Transparency Act, a very important and from our squeaky clean perspective, sort of delving into our privacy a bit too much act. But I think if you do this all right, or let us do it all right for you, I think it's all going to be good. So let's get this show started. So it's about new laws and potential liabilities. We're looking out for you to avoid big penalties by getting this filing done and getting prepared for the future now, hopefully, for everyone. So these are our attorneys, two now of counsel. So they're not going to be generally practicing law, but we're a good team. Here's all of our SoCal staff with most of San Jose, and then the estate planning attorneys travel around to the various offices around the state. So we're a good family environment, and that's the truth. We truly are. Here are those offices. If you don't know, we have them from Santa Cruz over to Sacramento, down to San Diego, and Temecula at the furthest distances. So what is the CTA and why? The CTA was passed on a bipartisan basis a long time ago, 2021. And it's taken this much time for them to start getting the details worked out. The goal is to combat people doing bad things. Money laundering and tax fraud being two, and then to minimize the criminal use of companies and even layers of companies to hide gains they have gotten from doing bad acts, none of which apply to any of us. It requires previously unregulated companies to provide information about themselves and their beneficial owners. So that is the first of the important defined terms in this act. The second important defined term is reporting companies. This is who the CTA covers as far as requiring reporting. And the general definition is any corporation, limited liability company, or a similar entity created by filing a document with a Secretary of State or similar office. Of course, it's a federal law, so it applies to all states. And then in addition, foreign entities who are required to register in the US are covered generally. And I just have a side note here, an aside. Vincent apparently has only about 300 employees. So there's real doubts among the legal community as to how they're going to do enforcement effectively, if at all. We will see as time progresses. Now, what is not a company? The exceptions are general partnerships and a sole proprietorship. Let's define those terms. A general partnership is a partnership, a multiple owner entity that doesn't have any owners who have only limited liability. Each of the partners has unlimited liability for entity claims against the entity for any reason. And then a sole proprietorship is one that generally a sole person or couple runs the entity. Those are not covered here. Trusts are generally not covered also. So the thought that you can perhaps hide your ownership in a revocable trust or irrevocable trust that you've done for estate planning or will do for estate planning next year when it gets more needed, those trusts are not covered. There's some trusts that other states have called business trusts or a Delaware trust that own a business interest that are also excluded. Now, the biggest list of exclusions is the 23 narrow exclusions. So these are mostly entities that are, for instance, regulated by the SEC. Sorry, I've got a little throat thing. But in another way, they could also have significant reporting duties. Banks, insurance companies, accounting firms, tax exempts are excluded happily. Large operating companies and wholly owned subsidiaries, which can report along with their parent. Excuse me. Now, factors regarding the definition of a large operating company are: one, if it's regulated already by a federal agency, it's not going to be covered. The feds already have all the facts on that entity. And then if you have over 5 million in gross receipts annually, over 20 employees in the US, and a physical presence in the US, those are factors that move you towards being a company, a reporting company for this purpose. And if it's a close call on some of those issues, then researching the little amount of FinCEN guidance is the thing to do. And I can do that for you if needed. The thought is that over-reporting is certainly better than under-reporting because of the high penalties. Now, to dig deeper in the beneficial ownership definition, the most important part is it's any individual who owns, directly or indirectly, 25% or more of the reporting company's ownership interests. Now, if no one individual owns over 25%, then all of the owners are beneficial owners needing to report. Further on beneficial owner, this is the second prong: any individual who exercises substantial control over the company. So those would be senior officers, anyone who can appoint or remove a senior officer. So that's probably going to be the board of directors. And generally, anyone who can decide important issues for the company. This focuses on actual authority, not your job title. You could be president and not have much authority, perhaps, in a certain situation. And that's where the attorney analysis is needed. I've got a little bit of guidance from FinCEN on the type of decisions that they are going to look to, whether you can make those decisions on your own. Who is a beneficial owner? Well, we've got this irrevocable trust slide that says anyone who holds a swap power is going to be considered a beneficial owner, because that means they can remove one asset from the trust in exchange for a substantially similarly valued substitute asset. And the holder of a currently exercisable power of appointment, that applies also to revocable trusts. And this is an aside point. You might consider amending your trust if it owns a reporting company or any part thereof to state who will be responsible for updating the CTA reports. It's generally going to be the trustee, but we can make that clear, or because it's a little more complex, you could state someone else is going to be responsible. You can't, as I indicated before, you can't avoid being a beneficial owner by putting the ownership interests into a trust. But if the trust owns 25% or more of a reporting company, then the owners are going to include So this is the revocable trust slide. The grantor or grantors, any others who can withdraw assets. We usually term those, the grantors, settlors of the trust, or even trustors in some cases. Then a trustee or a person with authority to dispose of trust assets differently than stated in the trust. If that trustee is required to distribute 1/3, 1/3, 1/3 of the remainder of the trust to certain people, that's just an administrative task. It's not, it doesn't give that trustee any discretion to make other distributions. So that trustee would not be a beneficial owner. So conversely, a trustee with the sole authority to make discretionary distributions is probably an owner for this purpose only. And that includes some trust protectors, which have become more and more popular. But most of those trust protectors don't have discretion to distribute property to people other than stated expressly in the trust. And the beneficiaries who are covered, the sole permissible recipient of income and principal. So that's like our C trust or Q-tip trust, where the survivor is the only one who can receive income and, if needed, principal. So they are considered a beneficiary for this purpose, and will have a look through the trust to see what percentage interest they are considered to own for CTA purposes. And then also a beneficiary who can demand distribution of all the assets. Obviously, they're going to be treated as an owner of anything they can get, acting on their own. The reported information, in my view, is pretty obvious with regard to both the individual owners and the companies. The things that are a little unique and scary in my case, in my opinion, for an individual, is you've got to give your driver's license with a picture of that driver's license. So all that info goes in to a secure federal database. And then on companies, you have to also list any trade names or DBA names so that they will really know all names under which you operate. They have to give a business street address. I think that's pretty obvious. And you can read the others. Now, we're popping back to an analysis and going deeper of irrevocable trusts. So the first step in the analysis is just looking at the document and identifying who really is a beneficial owner of the reporting company or companies held by the trust. And it's important to remember, as we mentioned, that some powers may be deemed to create beneficial ownership in the holder of the power. So that certain powers of appointment currently able to be exercised, not something that you might be able to exercise in the future. The swap powers of substituting one asset for another, the ability to demand distributions, sole permissible recipient, like the Q-tip, and perhaps crummy powers. Those in an irrevocable trust are an important power that is given to make sure that a gift is treated as a completed gift for federal income tax purposes, and gives the holder the right to possibly withdraw assets within a certain period of time, short period of time, no longer than 90 days typically. And then again, the trust protector rights have to be part of the analysis. Now, a shortcut that I'm going to suggest everybody use, especially if they want us to do the filing, because it's going to give you more privacy now and for the future. So individuals can obtain a FinCEN PIN, which they provide all their information directly to FinCEN and then get the PIN via email. And by the way, I see that I have gone all this far without really defining FinCEN. It is a Department of Treasury entity, agency, better stated, titled Financial Crimes and Enforcement Network. And so to go onward, so if the individuals get their PINs, then the companies disclose only the owner's names and PINs. So your residential address, your driver's license doesn't have to be available to all the other owners of the company. Now, this is an indirect ownership example, maybe not applicable to any of the viewers today, darn it, but I wanted to give one example of a shortcut, another shortcut. So a parent corp can report a subsidiary's PIN if the same beneficial owners exist for both companies, parent and subsidiary, and the subsidiary obtains and provides its FinCEN PIN to the parent. So that's only one filing needed instead of two by the parent and subsidiary. And I got a little note down here. The reason this works and is allowable is that an individual is a beneficial owner of the subsidiary just by virtue of his or her ownership of part of the parent. When do we need to file the reporting with FinCEN? Question, of course, initially, whether the business is a reporting company by asking, is it a corporation, LLC, limited partnership, or other entity formed by a Secretary of State filing? And if yes, does one of the 23 narrow exceptions apply? If no exception, then the company is going to need to report on one of these deadlines, on or before, I should say, one of these deadlines. So if the entity was formed before 2024, the drop dead deadline is January 1, 2025. But I almost want you to forget that and think that it's right now, because it will be too easy to forget and incur some really unpleasant penalties if it's not done on time. Now, for new entities that are being formed this year, they have to file within 90 days after formation. If we're forming the entity, we'll remind and assist, and for a separate agreement, we will do that filing for you also. And then finally, going way forward, on or after 1/1/2025, then you only have 30 days. That's after this system has gotten underway and we all know about it. Just as an aside, if we want to stop for a moment, there's some real concerns over whether the agency has done enough promoting, if you will. It's not something positive to promote, but advising the public on this need to file. We even find among attorneys, there's a lot of writing saying, what is this? And it's, you know, it's effective now as of a couple days ago, January 1. So tell your friends, I guess, is the message there. Now, those penalties I've been talking about. Anyone who willfully, means on purpose, or very negligently provides to FinCEN false, fraudulent, or incomplete information. Of course, that really should state, or fails to file at all. And then that's the first filing, the initial filing, and then ongoingly, they fail to correct or amend the information originally filed. And that's information that they either did not know or aren't charged with knowing as a reasonable oversight. If anything is really available to you, but you still didn't report it or report at all, then these penalties apply. On a civil basis, up to $500 per violation per day, with no limit to the aggregate. Or criminally, and with everything in me, I believe that's not going to cover our clients or prospects who are considering utilizing our estate planning. These criminal penalties are up to $10,000, 2 years in prison, or both. So hopefully those are going to be really big to the bad guys. And so they will avoid them by doing a filing. Who knows whether they will. If you do retain the firm to advise you and file the initial report, we will discuss with you the specific analysis of whether you have a reporting company and who the beneficial owners are and the deadline. Another aside, I was going to shorten the definition of beneficial owner to BO. It would have saved so much more typing, but I did not, for y'all's benefit. We will also file the initial report, and this you need to know. We have to be named on the filing. It's the first filing I've ever done on a corporate or partnership basis where I had to say who I was and give my social. Although I have to give it orally to the IRS when I call in. But in this case, we have potential liability for missing information. So in order to take your matter, we are going to have to, as all attorneys are doing, require all the required information on a separate little worksheet we're going to give you in advance, because we have to see that it's complete. Sorry about that, but we have to cover our backsides too. And then we're going to prepare a separate document, which I think is going to be of a lot of value, about how to prepare for future filings. Know that there's no automatic annual reporting needed. It's only important to file changes or corrections on a regular form to FinCEN. And like I said, we're going to do an instructions document that everybody who retains us will receive. And then if you follow this, you will avoid huge penalties. Now, with respect to privacy that I know everybody's concerned about, get the PIN so that you don't have to share all of your private information, especially driver's license. There's no Social Security filing for you, but the driver's license and residence address with the company and having it available to other owners. That's one very good idea. Everybody should request a PIN. And know that the database where all of this information, it will be stored, is protected at the highest security level. At least that's what they say. I believe that. I think that's accurate. Now, there's very, very important restrictions on who can get the info. Governmental agencies can request it based on activity that they think is related to, and of course, they're going to have reasonable cause, that is related to national security, intelligence issues, and/or law enforcement. And we want them to be able to get that. I'm not sure how broad intelligence is, but we want an agency to get things that will protect our people's information in order to protect our national security or law enforcement. And lastly, financial institutions and their regulators can obtain the information if the reporting company, consents. So that's a big if. Hopefully there just aren't going to be any nefarious uses by regulators. So in conclusion, how we can help. I recommend that you take action now when you have this information we discussed this morning. And for existing entities, you might be tempted to wait until later in 2024, since the information really isn't required until 1/1/2025. But I strongly request and suggest that you not wait, because the penalties could be huge if you end up missing that deadline. And once it's out of your mind, life goes on and you aren't going to be thinking about the Corporate Transparency Act. That'll be a benefit not to have to think about it anymore. So call in to schedule with me for your CTA filing and that information document for your ongoing efforts here. Now, some reminders about who we are as a firm. It opened since 1979. We have 8 full-time employees, 2 attorneys of counsel, and a CPA named Sunny Boren. Combined, we have over 350 years of attorney experience. Several of us have advanced tax degrees. Several of them in planning and trust administration are certified specialists in probate, estate planning, and trust law. We have 45 wonderful and highly qualified support staff. We have a diverse staff, I'm thrilled to say, and we have diverse skills. And then the 8 office locations I showed you, very willing to do Zoom and Teams video calls. We started that during COVID, but it's very popular still. So we have a team standing by right now to assist with any questions or comments you may have. We all look forward to hearing from you. So here's the 800 number to call. Here's our website if you want to learn more. And here's the email that you could use today. So I want to say thank you. Thank you for spending time with me on this topic. I hope it's been helpful. Have a great day.